We're Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Welcome everybody to another medical legal webinar organized by Dr. Shield and Chubb. Today's topic is on medical negligence. Do doctors face unlimited liability? Something which is hot in our discussions, bearing in mind recent court awards. And to discuss this, we have in our esteemed panel, Felix Raj, who is the founding partner of Felix Raj and Felix Raj Chambers, as well as Jafar Gopi, who is founder and CEO of Dr. Shield. Now, before we proceed, I just want to go through some housekeeping slides. There will be a short presentation on a very high-profile case, followed by a discussion by the panel, and also questions which you can pose to our panelists. Please use slido.com for this purpose. And if you have the Slido app installed in your mobile phone, you can enter 3303856 in the code for this specific event. Otherwise, you can scan this QR code with your normal QR code scanner and it will take you to the Slido website for this event. Okay, if you are watching from our main medical legal page in DOBBS, the Slido is already embedded there. Please don't forget to subscribe to our channel and hit the notification bell so that we can keep you informed of upcoming events like this and you won't miss it. For claiming CPD points for the dental doctors, there's already a attendance form which you have pre-filled, or it's not too late, you can still fill. It's dobbs.my/dentist1124. And you'll get your points from the Private Dental Association. For the medical doctors, we'll display the attendance link at the end of the talk. Okay. Right. So I will move on to before I bring I'll bring the panelists on only after the presentation. So now the presentation is by Joseph Lam, also of Felix Raj Chambers. And Joseph will be talking about a very high profile case, which is, and the subsequent High Court awards, which will be the prelude to our topic for discussion today. All right. So without further ado, I'm going to stream Joseph Lam's talk, which was pre-recorded.
Hi, good evening. I'm Joseph Lam. I'm a member of Felix Raj Chambers, and we are privileged to be invited by Dr. Shield this evening to give you a talk regarding the popular or oft-quoted case that's currently circulated in social media and also in the news, which is Siow Ching and Columbia Asia, Sdn Bhd. This is a recent federal court decision, which was handed down, if I'm not mistaken, in 23rd of February 2024. So without further ado, I will just start my presentation. Yes, an overview on Siow Ching and Columbia Asia Federal Court. To begin with, what is a breach of non-delegable duty of care? The Federal Court has defined the non-delegable duty of care as a doctrine that imposes liability on the non-tortfeasor, which is here the hospital, on a person who is not the one who committed the negligent act. In order to succeed in proving the breach of non-delegable duty of care, there are 5 features that was established by the UK Supreme Court in Woodlands in order for a claimant to succeed. First of all, the claimant is a patient or a child, or for some other reason is especially vulnerable or dependent on the protection of the defendant. Feature number 2, there is an antecedent relationship between the claimant and the defendant independent of the negligent act or omission itself, which A, places the claimant in actual custody, charge or care of the defendant, and B, from which it's possible to impute to the defendant the assumption of a positive duty to protect the claimant from harm, and not just a duty to refrain from conduct of which will foreseeably damage the claimant. It is characteristic of such relationship that they involve in an element of control over the claimant, which varies in intensity from one situation to another, but it is clearly very substantial in the case of school children. So I'd like to pause here for a moment and state that in most of the cases before Siow Ching, most of the cases falls at the second feature, which is the antecedent relationship. And I will explain further. The third feature is the claimant has no control over how the defendant chooses to perform those obligations. 4, the defendant has delegated to a third party some function which is an integral part of the positive duty which he has assumed towards the claimant, and the third party in exercising for the purpose of the function thus delegated to him, the defendant's custody or care of the claimant, an element of control that goes with it. The third party has been negligent, not in some collateral respect, but in the performance of the very function assumed by the defendant and delegated by the defendant to him. So most cases falls at the second feature, but unfortunately, or rather in the change of, there has been a refine of these principles, of these features in Siow Ching, and the second feature seems to be changed. So how has it changed, or how is it refined? We will go through the facts of Siow Ching first. In the facts of Siow Ching, the patient first went for tonsillectomy at SGMC on 10 March 2010. 12 days later, the patient suffered bleeding at the site of the operation and was brought to the emergency department of Columbia Asia, Puchong, simply because he lives near Columbia Asia. And thirdly, the medical officer who attended to the patient referred the patient to Dr. Megat, a consultant ENT. Dr. Megat then recommended the patient to undergo an examination under anesthesia and wound debridement under anesthesia. Dr. Noasila, the second defendant, was the anesthetist who attended to the patient. At the airlock of the operation theatre, the patient vomited copious amount of blood and was bleeding profusely. Despite the best efforts of Dr. Mega and Dr. Noasila, the patient suffered hypoxic brain damage. At the High Court, the High Court found that Dr. Mega was not liable because there was no causal link between the injuries of the patient to the treatment recorded by Dr. Megat. As against Dr. Noasila, the patient called Professor YK Chan as an expert to testify on this matter. Professor YK Chan, in her report, states the following. At paragraph 23, she was of the view that when the patient had more massive bleeding in the airlock and the operation theatre, anesthesia should not have been induced. Vomiting of blood, especially clots, showed that it was blood from the stomach swallowed earlier, and it did not constitute such a dire emergency that anesthesia needed to be induced. The next paragraph, the vomitus plus the profuse bleeding may have reduced the patient's ability to breathe, but this could have been suctioned suction away to provide a clearer passage for oxygen or air to enter the airway without the need to proceed with an anesthesia. His preoperative parameters taken by the nurses showed that it was not a life-threatening stage. By inducing the patient with general anesthesia, Mr. Siow lost control of his airway, and the anesthesiologist, Dr. Asila, lost control of the situation. Critically, at paragraph 24, the loss of control of the airway was for a prolonged period of time. Anesthesia was induced at 4:50 a.m., Code Blue initiated at 5:15 a.m., and it was also at 5:15 a.m. the airway was secured with return of good blood pressure, noted at 5:34 a.m. And at 5:35, blood pressure was at 136/72. Clearly, we can see here there was a substantial delay of time where the patient's airway was not controlled. And in short, the High Court found the following against Dr. Noasila. Negligence ought to be ascribed to the second defendant, and that it had become plain and obvious that her conduct had fallen below the standard of skill and care expected from an ordinary competent doctor professing the relevant skills based on which she was entrusted to treat the patient. As against Columbia Asia, the trial judge found both Dr. Megat and Dr. Asila were not employees, servants, or agents of the hospital, but independent contractors. Both patient and Dr. Noasila filed their respective appeals. The Court of Appeal dismissed the patient's appeal against Columbia Asia, but against Dr. Noasila, the Court of Appeal maintained the findings of liability and further increased the damages awarded to the patient against Dr. Noasila. I wish to pause here for a moment. It is in fact at this juncture the patient found out that Dr. Noasila's lack of indemnity coverage. The patient then proceeded against Columbia Asia solely, and they posed 7 questions of law. Now, I'll just go through briefly on the 7 questions. The first question is whether the owner and manager of hospital is in law, provider of healthcare, owes a non-delegable duty of care to patients. Question 2, whether the judgment of federal court in Dr. Kok regarding the tort of negligence in private hospital applies, but owner and manager of hospital owes separate duties of care in contract and by statute. Question 3, whether the owner and manager of private hospital should be liable for patients under non-delegable duty of care when doctor practicing in hospitals as an independent contractor has insufficient professional indemnity for malpractice. Question 4, whether owner and manager as provider of healthcare may escape liability for breach of such duty committed by a doctor simply because the doctor is an independent contractor who has been engaged to practice in the hospital. Question 5, whether there's a statutory duty of care independent of a duty, negligence, or contract owed by the owner and manager of a private hospital under the Private Healthcare Act. Question 6, whether the fees received by a director from a company are earnings by his own labor or gainful activity. Question 7, in light of post Dr. Kok, whether after applying the 5 feature tests in Woodland, a court must additionally apply a test that is fair, just, and reasonable to impose a non-delegable duty of care in the circumstances of the case. Leave was granted on 14th of February 2023 to the patient to appeal. On 23rd February 2024, the federal court by majority allowed the appeal against Columbia Asia and found Columbia Asia in breach of its non-delegable duty of care to the patient. The questions of law were not answered. So now we go through the findings of the federal court. The federal court found that all 5 features of Woodlands were present against Columbia Asia. However, it appears that the findings of the federal court in Siow Ching differs from the findings in Dr. Kok. In Dr. Kok's case, the federal court refrained from making a broad pronouncement to the liability of all private hospitals. It has to be decided on a case-to-case basis, as it is important to consider whether it's just, reasonable, and fair to impose such liability on the hospital. In Siow Ching, the federal court disagreed with such proviso and find that the Private Healthcare Act imposes a non-delegable duty of care on a private hospital. At paragraph 81, these were the findings made by the majority of the federal court. I'll just go through the highlight portion. While Mr. Su may have seen Dr. Kok both before and after the operation at his clinic outside Sunway Medical Center, the operation where the medical negligence and the cause of action took place was well within the walls of the hospital. Paragraph 82, in any case, given the extensive provision in Private Healthcare Act and the regulations, it cannot be ignored that the intent of legislation is that the respondent, or rather the hospital, assumes a non-delegable duty of care to the appellant, and it remains liable personally for the negligence of the second defendant. Paragraph 83, not only does common law no longer see hospital as mere providers of premises, utilities, facilities, or backup services for such treatment and care of a patient, the law provides that private hospitals are themselves providers of such care and treatment of patient, in which case the private hospitals or healthcare facilities or services owes a non-delegable and personal duty of care to persons who knock on their door and seek treatment and care. Now, this is the effect of the federal court decision. It appears that the latest federal court decision finds that once a consultant is liable for negligence, the private hospital too will be found in breach of non-delegable duty of care. Secondly, private hospitals now are required to ensure that their respective consultants have sufficient malpractice insurance coverage. 3, the 5 features of Woodland, while remains good law, it has been refined. And 4, as anticipated by the Association of Private Hospitals Malaysia, APHM, we are seeing an increase of medical negligence cases post Siow Ching. And this is what our views. First of all, we disagree with the findings of the federal court simply because if we look into the Private Healthcare Act, it was never the intention of Parliament to impose a non-delegable duty of care on private hospitals. Simply because if we go through the Hansard readings, first, second, and third, the introduction of the Act was merely to cater to the expansion of private healthcare facilities due to the growing list of private healthcare, such as maternity homes and nursing homes. The purpose of the Private Healthcare Act was actually to control and to regulate private hospitals, private healthcare facilities, by ensuring that there is a person in charge to be responsible of the private hospital. As for emergency services, which is in Siow Ching, Section 38 of the Private Healthcare Act was there to ensure that the public is able to receive emergency care when required. And 4, nowhere in the 3 readings or in the debates in Parliament, the MPs have actually considered non-delegable duty of care on private hospitals. 5, unlike Dr. Koch, it now no longer matters whether a patient chooses his or her consultant. It will be based on the location of the incident. So in our view, if Dr. Koch's case was to be determined again, there's a high likelihood that the outcome will be different. And 6, as I said earlier, the patient's choice of his treating consultant is no longer a factor to be considered in determining the breach of non-delegable duty of care. And in respect of the notice of contribution indemnity, yes, there are some consultants may argue that indemnity clause in your consultant's agreement is no longer applicable. In this respect, we are of the view that such pronouncement by the federal court were at best obiter dicta, other things said, simply because if we look into the facts of Siow Ching, it is strictly between the patient and the hospital. Dr. Nwasila was not a party in the appeal. So hence, we take the view that in respect of Siow Ching on NCI, we take the view that it's only an obiter, and private hospitals will still file the NCI should this matter go to court. 8, naturally, there will be an increase in medical malpractice premiums. Your premiums will go up because your coverage will increase, and such costs will be passed to patients and will lead to medical inflations. That's natural. Consultants, number 9, consultants who are in high-risk practice, i.e. anesthetists, such as Dr. Nwasila, ONG, will have to ensure sufficient malpractice coverage. What amounts to sufficient? You have to discuss this with your brokers. We strongly advise seek your broker's advice on this matter. And 10, as I said, as you renew your APC annually, we strongly advise to look through your premiums, your annual coverage regularly, simply because there is a possibility that a patient may file a claim right before the limitation period expires. In Siow Ching case, the patient filed the case. The date of the incident occurred in March 2010, but the patient filed it in 2017. So, and at 2010, Dr. Nwasila's indemnity coverage was only 1 million. So hence, my question is, you have to think about whether that coverage in 2010 is sufficient in 2017. 1 million coverage clearly is not sufficient. So our advice is look through your annual coverage, discuss with your brokers, and think whether you should increase your coverage. And to end, just to end this case, this slide, I'm going to show that there is a difference in Siow Ching and Dr. Koch's case. In paragraph 81, again, I reiterate, while Mr. Su may have been seen by Dr. Koch both before and after operation at his clinic outside Sunway Medical Center, the operation where the medical negligence and cause of action took place was well within the walls of the hospital. As for Dr. Koch, the personal choice of a patient is not an independent test in itself, but a relevant factor in applying the Woodland analysis, in particular in determining whether there is an antecedent patient-hospital relationship from which to impute an assumption of responsibility by the hospital towards the patient. So post Siow Ching Yi, we would say that there is a refinement of the 5 features of Woodlands, and it appears that now the choice of consultant is no longer a factor in determining whether there is a breach of non-delegable duty of care. So hence, that's why we strongly advise consultants, again, please check your coverage, see whether it's sufficient, speak to your brokers. If you need to, please increase your coverage. That is all. Thank you.
Sorry, yeah. I have to unmute my mic as well. Yeah, thank you, Joseph, for your excellent presentation. So Felix, your mic is muted, so you need to unmute it.
Yeah, I'm unmuted. Can you hear me?
Yeah, excellent. And Felix Raj, of course, is the founder of Felix Raj Chambers, and for representing the insurer side is Mr. Jafar Gopi, who is the founder and CEO of Dr. Shield. So welcome, gentlemen. And we've lost Felix Raj's camera and, and microphone. We hope to get you back. All right. Yeah. Felix, you there? Yeah. Let me see if there are already questions in Slido.
Yeah, I'm back. Sorry.
Yeah. Okay. Just to remind you guys, if you have questions, do ask on Slido. And the code for the event is 3303856 on Slido. Okay. So, yeah.
Yeah, if I can add on to Joseph's presentation, with respect to the Siow Ching Yi matter and federal court decision, right? Just to share to everyone, the reason why we have shared this decision, apart from the fact that everyone is talking about it, right, since the decision came out, is to share with you and emphasize that the need for the consultant doctor, right, to ensure that they have proper or sufficient indemnity cover, and that is subject to your area of specialization or your area of subspecialization, right? The risk of your practice, right? And why this is relevant is, for example, at the High Court, what was ordered against the consultant, right, was 1.9 million. And at the appeal in the Court of Appeal, right, that was enhanced by the Court of Appeal to 2.1 million. And why is this relevant? It's because the appeal at the federal court, to go to the federal court, as Joseph has pointed out, you need to raise questions of law, get the leave of the federal court, which is the permission of the federal court, which is our apex court in this country. And at the federal court, the respondent, the sole respondent, right, was Columbia Asia. Dr. Asila was not a party or was not a respondent in the federal court, right? So in the federal court then made an additional award, which was payable against Columbia Asia itself, about R1 million, right? But when you go back to the Court of Appeal, because Dr. Asila was not a party in the federal court, the award of damages against her was about 2.1 million. And that 2.1 million is for her to pay, for her and her indemnity providers to pay, right? Of course, we are not aware of what her indemnity was, right? And who her insurers were, right? But assuming that her indemnity from her policy was just 1 million, right? She had to then fork out another 1.1 million on her own. So that goes back to the topic of this discussion today of the unlimited liability of a consultant. All Columbia Asia has to pay is what was ordered by the federal court, and that's it. But Dr. Asila is left to pay, right, whatever over and above her indemnity limit. And don't forget, right, Jafai can correct me, but your indemnity limit on professional indemnity covers for medical negligence also includes defense costs. So you can imagine the defense cost that was incurred in the High Court to defend her solicitors appointed by insurers, and then in the Court of Appeal. So if her total, let's say her total indemnity under her policy was 1 million, and the defense cost had eaten up, say, 300,000 for the High Court and the Court of Appeal, all that's left is 700,000. So that enhances the position as to why it is important for doctors, for consultants, right, that you need to ensure that the indemnity that you take, the policy that you purchase, right, has sufficient coverage for you, right, in situations such as this. You don't want a position where you are left to deal with something where you have to sell your property, and that has happened in enough and more of our cases. Sell your own property, divest, borrow from friends, family, right, to pay, right, what you have to pay because it's outside your indemnity cover. And that's the critical point as far as this discussion is today on this webinar, right? The need to ensure that you, one, understand the coverage you're taking, and to understand the coverage you're taking is you need to look at your specialty, your subspecialty, and the risk that arises from it, right? And ensure that you obtain adequate coverage, as in what is the total coverage in quantum, right? And you need to look at the terms and conditions of your coverage from whoever your indemnity provider is. You must understand that there are many coverages out there, right, for doctors, right, that does not cover aggravated damages. And that's something you need to bear in mind. It does not cover aggravated damages, and by far and large today, looking at the cases we're handling and the judgments that are coming out, it's quite often that the High Court, which is the court of first instance, right, by far and large, awards aggravated damages. So, for example, even if they just awarded aggravated damages of 100,000 ringgit, right, the highest is 1 million. But if they awarded 100,000 ringgit, and if it's not covered by your policy, then you have to find the money, right, to pay that 100,000. So the reason why we started off with Columbia Asia, the Siow Ching decision, is to share with you, look, the consultant is liable for up to 2.1 million based on what the Court of Appeal had enhanced. I'm putting aside interest and cost, right? It's 2.1 million, right? Subject to whatever her indemnity limit was. And whatever that was awarded vis-a-vis Columbia Asia is for Columbia Asia to cover. And the other thing to point out, which I'd like to bring forth at the front of our discussion, is as Joseph had shared, right, the discussion about the notice of indemnity and contribution, which most of you would be familiar with. So when there is a lawsuit, when there's a medical malpractice suit filed against a consultant and hospital, right? The consultant is an independent consultant of the hospital. You have a consultancy agreement, right? And one of the terms, by far and large, in your consultancy agreement is an indemnity that you provide as a consultant to the hospital in the event of issues of negligence. So when a suit is filed by the patient as a plaintiff against the consultant and the hospital, eventually what the hospital will do once it's filed its defense is it files something called a notice of contribution indemnity against the consultant. It is not that the hospital is taking a position against the consultant. That's not the case, right? But it is pursuant to the indemnity provision in the consultant's agreement, right? Now, when the hospital does that, right, eventually, if this matter is not settled, it goes through a full trial process and the judgment is issued, just like in this Columbia Asia case, right? The court will then have to make a decision as to whether to allow the notice of indemnity, right, by the hospital against the consultant. Now, in cases, so there's a distinction here. In cases where it is the sole negligence of the consultant, right, and the court makes a finding of vicarious liability or breach of non-delegable duty of care, Columbia Asia's case is purely on non-delegable duty of care. Vicarious liability is still Dr. Cox's case that Joe had referred to earlier, the Sunway case, right? The law on vicarious liability is in there. Non-delegable is in Columbia Asia's case, right? Okay. So if the court makes a finding of non-delegable, breach of non-delegable duty of care by the hospital, that the Woodland principles are fulfilled, for example, right? But, and then goes on to make a finding that in favor of the hospital that the notice of indemnity is allowed, right? When what that means is, if the court makes a finding that the notice of indemnity is allowed at 100%, it then falls upon the consultant doctor to bear the full 100% of the judgment. What I just want to share about Siow Ching Yi is, with respect, her ladyship, Dr. Mary Lim had, in closing of her judgment, her grounds of judgment, had remarked that, among others, that the notice of indemnity does not apply. Of course, as Joe has shared, we take the position that Dr. Asila was not a party to the federal court. And what, with respect to Dr. Mary Lim, is that her position was, one, she's not a party, right? And hence, the position is there's nothing to consider but the notice of indemnity. Of course, she did go on to say, right, that given her decision, right, and the federal court's decision referring to the Private Healthcare Act and the regulations thereto, that the issue of indemnity doesn't arise. But what we like to share with you is that the position that FRC takes is that it's an obiter dicta. That means a comment in passing by a judge. It is not the ratio decidendi of the case. So, Columbia Asia does not give, it does not amount to a carte blanche, right? That, if the consultant is found solely responsible and the hospital is then found to have breached his duty of non-delegable duty of care, that the consultant can take a back seat and say, okay, it's fine. My indemnity is so much, the balance will be paid by the hospital. Because if the indemnity is allowed, the NCI is allowed in favor of the hospital against the consultant is 100% liable. So it is, you cannot look at Columbia Asia and say, oh, it's done and dusted. 100% I'm covered, right? So long as the hospital goes down with me. So that's what I wanted to share in further to what Joe has already shared with all of you, and the relevance of Columbia Asia to our discussion today about unlimited liability of doctors. Yeah. Thank you. Thank you, Dr. Alu.
Thank you, Felix. I think we are waiting for more questions to come in, but we want to cover the issue of what is, what indemnity doctors should take up. Yeah. There's a common question. I mean, how much to cover? And then as far as how do different medical specialties, impact this liability risk? So maybe, Jafar, you want to share your thoughts on this?
Yep. Good evening. Good evening to everybody. Do doctors face unlimited liability, I think that's a very relevant topic, very timely topic. Thanks for this webinar topic. I think there's a lot of doctors out there who have been swayed by the mandatory requirement and they are started buying insurance for APC, right? So much so that a lot of them have actually forgotten that it is their liability that the insurance is helping to defray. And that is something that we have to keep reminding them that they are personally liable for it and the insurance is there to protect them. Yeah, it's very important they understand the relationship. And I'm also going to go back to a few topics, few pointers that Felix said. Aggravated damages, yes, I think it's becoming quite a common payout, and not all insurance policies by default cover aggravated damages. So that's important point to take note. And for all the doctors out there, aggravated damages has to be covered in your policy if you want that to be covered because of course the trend, and that's something which you may want to check with your policy issuers, your insurance companies. And the second point that Felix mentioned about defense, that's a very good point because in the event that for example, if your insurance coverage is 2 million and you've got a payout of 2 million and your defense cost comes out to say $500,000, right? Typically, all insurance companies will pay their max up to 2 million, which means the legal fees will have to be borne by you. Unless otherwise, they have an extension to say defense cost is limit in addition to your sum assured. Then it's fine. Right? So they will pay the 2 million and then they will pay the defense cost in addition to the sum assured. So these are the 2 pointers that I wanted to touch based on what Felix had mentioned. And Ellen, you are asking about the question, how do different medical specialties impact liability risk?
Yeah.
Was
So
it
I
your
mean, the
question?
common question in our forum is how much should I cover? Maybe from a junior medical officer who does locum, and Sugdeshan in YouTube is asking, he's a retired GP and then does some locums. I mean, how much should these doctors be covered versus the high risk ones, which Joseph mentioned, which are anesthetists, ONG. I mean, some insurers will give guidance, and like MPS will have they give low risk, high risk, etc., and then you tell them which risk they fall into, and then we pay accordingly to get the appropriate cover. Some insurers you have to decide yourself. They give the flexibility, but with the flexibility comes either you under insure or you over insure. So what do we do in the light of increasing liability, which looks like it's going sky high and becoming unlimited, and now also with legal defense taking a big chunk of whatever the doctor has to pay. Yeah. So how do you guide the doctors?
So, I mean, if it takes this, yeah, sorry, Felix, you want to carry on?
Sorry. If I can just jump in for a moment. Sorry, Jeff. Just to share with everyone, right? The damages being awarded for medical negligence is not going to get any lower. It's going higher, right? And one of the reasons for that is very simply, for example, if you have a brain damage, say child, even an adult, even worse for a child, right? Say brain damage at birth, right? The multiplier, which is the number of years that the child would live, which is subject to expert evidence, which the court will decide, okay, right? The multiplier will then be used, right, in calculating the damages for the child, right, based on the child's life expectancy and the needs of the child. So from simple things as diapers to attendance in the hospital for various treatments, etc., right? The cost of medicine, the cost of medical treatment in a private hospital, undeniably, everyone knows here, is going up. It's going to go up next year. In fact, I think recently I saw something that said that medical insurers are going to increase their premiums next year. So everything is going up. So that's a factor.
I beg to differ. I think the doctors will tell you that what has not gone up is the cap on professional fees,
Oh, yeah.
which has over 10 years has not gone up.
Your
Has
fees
been
is
capped.
stuck. Yes, doctor, your fees are stuck with Schedule 13, right? Which caps your fees.
So
right?
not everything has gone up. The doctor's
No, what I'm
fees
saying
have
is,
been capped.
what I'm
Yes.
saying is, I know I understand what you're saying, but what I'm saying is the cost in a private hospital has gone up, is going to go up, right? And recently, a certain judge at the seminar actually said, by far and large, awards for medical negligence is going to go up and will keep going up because of medical inflation, right? So I appreciate, doctor, that you guys are stuck with the 13th schedule, right? But what I'm trying to share is that it's going to go up, which means when the courts make an award, they will be cognizant of the fact that cost is going up. And any rehab expert that gives evidence, writes a report vis-a-vis whether for the plaintiff or for the defendant consultant or hospital, right, would be clear in their minds about the fact that the cost is going up. So now I leave it to Jafar about the fact that you have to take into account. The reason I brought this up is you can't, for example, an ONG expert, an ONG consultant, right? I stand corrected by Jafar, but I don't think a 5 million ringgit cover is going to cover you, honestly.
Yeah.
Yeah.
So I wanna, I mean, this is there's so much of talk about how much to cover thanks to the recent large settlements, right? But I just want to bring the attention, right? These cases were started many years ago, right? Whatever the public is hearing today were cases that have started 3, 5, the other particular one 10 years ago. So therein lies the answer of what we are expecting in the near future, right? They'll be surprised, but the amount of claims that are happening today, which are actually quite aggressive, right, are not known to the public because it is not come to the court stage yet. It has not come to the verdict stage yet, which would come only 3 years later, right? But you can rest assured that the frequency and the claim amount is actually getting very, very aggressively bigger and higher, right? So that's the inside information that I can share with you guys today, right? And how much are you supposed to be insured? Let's also assume that a typical case takes about, say, 3 years, based on the previous verdicts, right? So 3 years later, when a verdict comes out, today's insurance limit, when you first notify the insurance company, applies. So let me put it another way. You have to be sufficiently insured today for a verdict that probably can come 3 or 4 or 5 years later, right? And then you have to factor in the inflation that Felix was mentioning. If you want a quick answer, of course, we can say, yep, all low risk doctors should get at least 2 to 3 billion. Medium should go for 5 to 10, and high risk should be looking at more than 10 million. Of course, that's an easy answer. Yes, if you're looking for some kind of guidance, that could be the answer. But it is very important that you realize that this is a serious issue ahead. We are all talking based on what we know today, which were mooted 3 years ago, and we are not talking about what is happening today's claims, which you would soon see in large numbers, big amounts. So are we prepared today for a verdict 3 years later? That's a question that I leave with to all the doctors.
Yeah, and if I can just jump in here, just to share with all those who are attending this webinar, the Limitation Act with respect to filing a claim for negligence, right? For an adult is 6 years, right? If the adult passes on, right, the dependency claim has to be filed within 3 years of the death. If it's an estate claim, it's still 6 years. But the one that is more concerning, right, is if it involves a minor, right, the minor has 6 years after the minor turns 18. So, so maybe, if I can invite Jafar to share about uh, claims-based policies, occurrence-based policies, and if you retire, how do you ensure you have the coverage when you retire? Yeah.
Okay, so I think it's important to touch base again on the differences of claims made occurrence based policies, right? So occurrence based is whereby you have been insured at that particular point, yep, and you have paid the premium for that particular point of that year where the incident happened, and then you are covered for life, right? This is occurrence based insurance policies, which are very rare, uh, very one or two left, right? The rest of the insurance companies offers claims made. That means as long as you are a paying client of the insurance company and you get a claim for the first time, you know about it, right? Which could be coming from last 5 years or 3 years or 6 years, you would be covered for that. And that's what's called claims made. And for claims made, you have to be a consistently paying client. Although claims made is a very linear structure, but for you to remain under coverage, you have to keep paying the premium year after year. So occurrence base is a luxurious cover. When you pay that particular year, incidents are covered for the rest of life. Okay, that's occurrence base. Even if you don't pay, that's fine. Claims made is whereby you must be a paying client of the insurance company when you first know about a particular incident, and then you'll be covered. But in this claims paid insurance format, where most of the insurance companies follow today, you need to be a paying client year after year. Third scenario, what happens when you retire? So if you're under claims made and you retire, then there's something called runoff. Okay, most insurance companies will offer you a runoff coverage if you have been with them for 5 years. Please check it with your insurance company whether they do. Yeah, but most, I think, in my opinion. But in the event that they do not have such a feature, most of them would also offer you an opportunity to top up your insurance and buy a runoff coverage in the last year before you retire. So what is this runoff coverage? Runoff cover means you have an insurance coverage that lasts after you retire with protecting you and your estate. So if there's a case, if there's a claim that is notified after you retire, right, they will claim from this runoff insurance coverage. That would follow the sum assured of the last year of your retirement. So that's how the runoff cover works. So it's three types: occurrence made, claims made, and runoff. That needs clarification. Yeah.
So for the claims base, now
Claims made, yeah.
as we go back to the topic again of so-called unlimited liability, I think the highest court award to date is over just shy of 10 million, if I'm not mistaken, for a boy with cerebral palsy. So now, is there a limit to what we can cover? Does the claims-based insurer limit how much you can take? If I'm a very high risk, if I want to take a 20 million coverage, would the insurance company balk?
I think there are. Yeah, it depends on each and every insurance company's focus and what's the offer. Yeah, I'm sure there are insurance companies that offer up to 20 and even 30 million.
Mm.
Yeah, they do. So depending on the insurance companies, there is a limit that can go up to 30 million. Yes, it's possible.
Okay. The second thing, just want to clarify also, it seems like, as you say, things are a moving target and it seems to be getting worse and worse. We'll talk about how these things can be mitigated, but can the coverage be changed in the policy? Let's say 2-3 years down the line, they want to revise upwards. Any issue?
The moment there's a claim that has been notified, during that point of time, whatever coverage they have paid for is the coverage that they will be triggered for their policy.
So if there's been no claim yet, I want to increase the insurance.
Of course,
coverage.
you can. Yeah. If there's no
All right.
claim, you can of course increase. Yeah, no,
Okay.
nothing.
So once it has been claimed, then you're stuck at that.
Yeah, for that particular incident, you are stuck at that.
Okay.
Yeah. Nothing stops you from buying more insurance after you get a claim, but it will cover you for other future issues, not for the particular claim that has been already notified.
And to protect ourselves, is there any benefit in getting more insured by more than one company? One PII?
I think it's asking for trouble. Yeah. Then you are going to create more problems between two insurance companies, and that's something which is a topic for another day.
Yeah.
Felix can touch on it if he wants.
All right. So thank you for giving us the estimated range. So low risk about 2,000-3,000, medium risk 5 to 10, and
3
high
million.
risk above 10. Generally at the moment.
Yes.
Yeah.
Yes.
Okay. Right. And runoff coverage you mentioned also, because it's important after one retires or stops working, it also or passes away, it protects the estate. That's what you're mentioning. Yeah. So we have to
Yeah, I think it
think
is
about all
worth
these things.
talking
Yeah.
about this. Yeah, I think it's worth emphasizing. I think it would be great if Felix can touch upon this. A lot of doctors who I've met in recent times during some networking and speeches, they may not really completely understand that they are sitting on unlimited liability, and they may also look quite shocked when they understand that the plaintiff can go after the estate should they not be around at that point. So maybe Felix, you may want to emphasize on this particular point.
Yeah, I mean, if maybe I can start off with, the topic of our discussion being unlimited liability as far as individuals are concerned, consultants, right, doctors. Remember that, your the limit to initiate bankruptcy proceedings against an individual in Malaysia is 100,000 ringgit. And as Dr. Allen has shared, right, currently the highest award stands at about 9.4 million ringgit for medical malpractice. Okay, right. That is against a government hospital, right? Now, going back to what you're going to look at, if I can touch first on your coverage, right? I think you need to ensure that you have good brokers, right, who advise you. And you need to be transparent with your brokers as to your area. Obviously, your area of practice will be there, right? But what potential subspecialties you may be doing? For the simple reason that medicine is not stagnant. It's always advancing and advancing, sometimes literally on a daily basis, from medication to treatment to procedure, right? And you need to be transparent with your brokers so they can share with the insurers, right? That this is your area of practice. Because you must always do a self-assessment of your own risk. You have to do that. And that's subjective, right? You can fill up a proposal form. It may not tell everything to your brokers or the insurers. So you have to bear that in mind, right? And when it comes to what is a sufficient amount for your indemnity limit, right? That again goes back to your area of practice, subspecialization, and risk of practice, right? And you must understand that, some of you may have faced this, that the hospitals that you practice in today, private hospitals that you practice in today, may already be telling you that your coverage is insufficient, right? And telling you to up your cover, right, based on your area of practice and the risk of your practice, right? Now, when it comes to what I said earlier, look, bankruptcy threshold against individual is 100,000. Now, we have cases already, we have seen over the years, and we have current cases where what is happening is, unfortunately, the consultant has passed on, right? Naturally, of course, the negligence or the alleged negligence occurred whilst he had was alive and undertaken whatever procedure or treatment for the patient, right? He is passed on, and what happens is the patient plaintiff right, files a claim against the hospital and also against his estate. So it's long tail, right? You have to ensure that you have coverage that protects you in the event of your demise. Acts of negligence that purportedly arose whilst you were alive. And that's where, again, you need to engage with your brokers and ensure that you have that sort of coverage. Because very simply, the unlimited liability that you have, the reality is it carries on well past your death. Remember what I said to you, if you're an ONG consultant or PETS, right, the child can still sue you age 18, 6 years. Long tail, right? You have to remember these things, right? You have to protect your estate. So whilst you're alive, you protect yourself with adequate coverage and ensuring that you understand the terms and conditions of your policy and what it excludes and what it covers, right? Especially what it does not cover. And always remember, like Jafar said, the limit, if it's 2 million, includes defense cost, right? Now, you need to ensure that in the event you pass on, that your estate is covered. So yes, so this is the dual position, right? And I will share with you, right? Because some of you may look back at Columbia Asia and say, "Oh, but you know, if I go down as a consultant, the hospital is going to be automatically found liable, right, for breach of non-delegable duty of care." I can share with you. Recently, there was an appeal in the Court of Appeal, right? We were acting for the hospital. The High Court decision was made pre-Columbia Asia, that means before Columbia Asia, right? And at the High Court, our client, the hospital, got 100% indemnity against the consultant. That one consultant was found solely negligent, right? Unfortunately, another anesthetist, but found solely negligent, right? The Court of Appeal just delivered their decision. The Court of Appeal's decision is post-Columbia Asia, right? And of course, there are a lot of arguments about Columbia Asia in the Court of Appeal, right? The fact that, the hospital should be found, that there should be no indemnity and automatically liable under non-delegable duty of care, right? The Court of Appeal decided, right, to affirm the High Court decision and gave the hospital 100% indemnity. So don't think Columbia Asia is the one and all. No, it's not. The law evolves. It's changing, right? Why the Court of Appeal decided what they decided? Well, that's a debate for another day. But they decided, and they allowed the hospital's indemnity, the NCI, against the consultant 100%. So, going back to what I said earlier, right? Don't think that Columbia Asia is the end of all. Oh, I'm done, I'm covered, because the hospital will go down on me. No. You have to bear this in mind. You have to be conscious. You cannot treat your medical malpractice cover, right, as if it's your motor insurance cover. You can't. All authorized drivers covered, I pay extra, or I don't have to pay extra. No. You can't. You have to scrutinize your cover. You have to understand what your cover is. And that's why it's important to have good brokers who share with you, okay, it's like this. Okay, doc, you're not covered for this, you're not covered for this, you're not covered for aggravated damages. But you want, okay, then it's covered this way. Your premiums get adjusted, right? It's something that Jafar can share as far as Dr. Shield is concerned, right? There's so many different covers out there, right? You need to know what you're covered for and what you're not covered for. And that's very important. And whether, as Jafar shared, its claims made, occurrence base is fantastic, but it's not available everywhere, right? And, the long tail, right? And how you protect yourself. So it's very important, and in our discussion today, that you have to ensure you protect yourself.
Yeah. Sorry, just to jump in, legal costs is part of the sum assured for many of the insurance companies. So that was the point that I was trying to say. But there are certain insurance companies, insurance schemes like Dr. Shield, that has defense cost that is in addition. So our defense cost doesn't eat into the sum assured. So ours defense cost is the addition to the sum assured that is paid for damages. So you just need to look out for what your insurance policy covers, because most of the insurance sum assured would include defense costs. That's where it could be a trap. But yes, ours is independent, so that's fine. Yeah.
And we have to
Another
know
question.
also whether aggravated damages are covered and
Yes.
whether
Yes. And that's
all
another
these,
very correct. Another point which I thought I should take this opportunity to explain. Right? Like what Felix keeps mentioning, right? You need to know what's your coverage. Because you're buying an insurance cover that is supposed to protect you. A very key difference of when the insurance policies get triggered. This is something very interesting, right? You have to understand, when does your insurance policy actually trigger? Does it only trigger at the point of a litigation, or does it come in early to mitigate the risk?
Yeah.
This makes a big difference. Let me explain, right? If your insurance policy does not cover loss mitigation, that means your policy only triggers. That means you can only engage a lawyer when you have a legal suit that has been initiated against you. In my opinion, that can be quite late. So if you have an insurance coverage, you may want to find something with loss mitigation, because loss mitigation means you basically have a lawyer that the insurance company can engage for you to try to settle, to try to negotiate, try to sort out as soon as you know that there's going to be leading to a bigger problem. Because the best way, or the best point to solve a problem is at the start of it. So that's very important to know the difference.
yeah, I think we maybe you want to elaborate, either of you, what the process of mitigation, what are the things which both involved before the actual litigation.
Well, if I can completely agree with Jafar that loss mitigation is actually very important, right? You see, in circumstances where, look, let's be honest, right? If there is a demand upon the consultant, right, and loss mitigation is not provided for in the cover, but there's a demand, say, for example, some lawyers will write, patient lawyers saying, give me the medical records. That belongs to the hospital, right? But they will set out their demands. And today, right, many of them actually, in fairness to them, right, they are able to identify at least the first areas of negligence that they see, right? Because there's always somebody else on board assisting the plaintiff solicitors or the patient solicitors. Patient solicitors, because the claim is not filed, right? So if the loss mitigation is not there, the consultant is left on his own. Would that be correct, Jafar? Right?
Absolutely, yeah. Because they can't engage a lawyer. Yeah.
He can't engage a lawyer, right? So he's left on his own, right? And then he's hard pressed to deal with, because don't forget, it could be a cumulative position where a demand is issued on the consultant, right, alleging whatever issues of negligence. A similar demand is then issued on the hospital, right, seeking for discovery of the medical records, right, and raising a grievance mechanism which is provided for, right, against the consultant and private hospital, right? Okay. So the consultant without loss mitigation is left alone to deal with things. The hospital, by far and large, will most probably have coverage for loss mitigation. Or let's not forget, it's a large organization, for example. It's an organization that, even if she doesn't have loss mitigation in her cover, the hospital can engage solicitors and happily pay them and say, hey, can you handle this? Right? But the consultant doctor is alone, right? And eventually what the hospital is going to do, if it's a clinical issue, it's purely a clinical issue, right? They're going to write to the consultant and say, can you please explain, right? Or your response as a consultant who treated the patient because it's clinical, right? With respect to the allegations raised by the patient or the patient solicitors by way of the grievance mechanism. And the consultant has no one to help him. And it's very important that you have an independent third party, your solicitors coming on board, because imagine the pressure when you have allegations of negligence, demand made against you. It's a sword on your head. Let's be frank, right? And you want help, but you can't get help unless you pay for it on your own, right? And if you decide that I'm not going to pay for this on my own, I'll just do this myself, and if it's one of those cases where I say there's no mortality or morbidity, there's no need for the hospital to do a review under that, right? But it's purely a grievance mechanism, right? You decide to handle it yourself, right? You get into deeper trouble. You need a third eye, an independent view to look at it and say, okay, look here, doctor, I'm gonna look at this differently, because I'm a solicitor. Thank you for your answers to the grievances raised by the patient. This is how we're going to draft it because we're going to make it kosher. And that's what lawyers do. Make it kosher, right? And move it to the next stage, right? So loss mitigation is actually very important. Very, very important, right? And doctors advise, consultants advise that you must ensure that your insurer will step in. All you have to do is, I got this letter, right? Notify your brokers, they notify the insurer, and voila, you got your solicitor there saying, okay, doctor, we're here. You cannot handle it yourself, especially when you have, let's be fair, you got a sword over your head as a consultant, right? And especially when it's your first claim against you, the claim may be frivolous, but it's still a claim. And you're an individual, and this is your source of income, this is your livelihood, right? You want to have that independent advice, somebody that looks at your drafts and says, oh, doctor, you can't say this. Let's be frank, any of us, right, as human beings, if we have something, a claim against us individually, right, there is a sense of emotion, you get emotional about it, so you don't think rationally, right? So you give your answers and your solicitors will then say, oh, okay, doctor, it's like this, it's like this, it's like this, this is how we'll draft it, we'll keep it kosher, right? And then we see what the response we get. So the loss mitigation, like Jeffai said, is very critical. It's very critical.
Let me give a simple example, right? A particular doctor gives an injection that goes wrong, that has got very bad side effects. This particular family goes through additional unnecessary hospitalization, goes through pain, comes back, bangs the table and says, you have to pay for this 1 week of my stay and give me my income for whatever I've lost, right? And I'm extremely unhappy with you. Okay, so this is a scenario, right? You call the insurance company and you tell them that, this particular unhappy situation, it looks like I may have, done something wrong. But if you do not have a loss mitigation, the insurance company would tell you that there is no case yet. Sorry, we can't trigger the policy. And this is the last thing that you want to hear. So my question to all of you who have been covered by whatever insurance company that you have, it's a question to ask your brokers and your insurance company, at which point does your policy get triggered? That would be the best way to understand the impact of mitigation versus litigation. At which point does your insurance company say, okay, now is the time when I will come in, I'll set a lawyer for you? Because in the previous example that I gave you, if you do not address that particular family that comes back to the clinic to ask for that settlement, right? What they would do next? Let me just jump to this scenario. They would find a plaintiff lawyer. The plaintiff lawyer would prepare the case. They would call for medical experts, build up the case. They come back strong with you. That would be guaranteed many times more than what they would have initially asked for. And this is going to drag many months longer than what you could have actually avoided. That's like a
Actually,
sword, like what Felix said. That's like a sword hanging over your head. Yeah.
actually, if I can echo further what Jafar said, right? Actually, in the cases where the consultant actually has lost mitigation, right? And if it's indefensible, right? And let's be honest, like, consultants will tell us straight off, look, there was an error, lah, right? Okay, between the consultant and the hospital, right? So when such a position and it regularly arises, right? What you have is with the loss mitigation clause protecting the consultant, that means insurers are protecting the consultant, insurers for the hospital, right? There will eventually be a meeting of minds, right, to resolve the matter. So I can tell you straight off, we don't seek to litigate, right? The end of the day, right, you have to decide as consultants. If you made a mistake, just be frank about it that you made a mistake, but you don't have to share with them. I'm not telling you to share with the world at large, right? But you accept that position, you tell your lawyers, you tell your insurer, and you're frank with the hospital that you practice in, right? And there will be a meeting of minds to resolve the thing. We have done this multiple times for many years, where we just settle a claim before it's even filed. And that is actually the best or the most favorable outcome, right, to an indefensible claim. So what does it do? It's closure for the patient, closure for the consultant, the sword is gone, right? Practice with the free mind, right? And closure for the hospital. It's a win-win for everyone. So,
Yep.
so what Jafar said is you need to have this in your policy, right? That the insurers will step in and not say, hello, you're on your own, right? When a writ is filed or when a letter of demand is issued for a quantum, right? Then notify us. You don't want
It's
that. You
too
want
late.
the loss
Yeah.
mitigation. Yeah.
Yeah. It's too late to the party. Yeah.
Yeah. It's
Yeah.
too late to the party. Yeah.
So usually for us in hospital practice, it means there's always a grievance mechanism. Actually, it's required by law that you should make known to the patient that there's a grievance mechanism. If it's a hospital, usually there's a meeting with the patient to resolve all these complaints and grievances, and it may or may not. I think what you're suggesting is if things are not looking, engage legal counsel earlier, even before litigation. So this is the mitigation state where you inform the insurer, and it's the trigger, isn't it? Even
And
uh,
doctor,
yeah,
this
yes.
is why it's important is because,
Mm.
right, very critical in this country is that consultant doctors are insured by different insurers independently. Hospitals have their own insurance.
Mm.
It is not a common insurer.
Yes.
They're different insurers, right? And you must understand that, just to share with everyone, right? Because the consultant has, let's say the consultant has insurer A, the hospital has insurance B, right? Both the insurers will appoint different lawyers to act on the matter and advise on the matter. You see? And eventually, both the solicitors need to advise their clients, depending on the circumstances, to see, for example, if it's indefensible, whether there's a meeting of minds and how to settle the claim. And then there's a share on liability. So, what is important for consultant doctors to realize is, right, why mitigation is important, as Jafar shared, is you need somebody to advise you, to guide you. You're not alone, And as I've shared with Jafar before, right? We have acted for consultants, and there is a psychological impact when you have a claim against you, right? It does not matter how many years of practice you've had, right? That somebody says you've done something wrong, right? That you're negligent, right? And but you feel inside that you didn't do anything wrong. but it impacts you. It impacts you mentally. So it's important that you at least have, somebody to reach out to, which is your solicitor, right? I'm not saying your solicitor is going to be a psychologist, right? Who can give you, some level of comfort, right? But at least you're not alone, and that's very important. Don't be alone in that journey when you face a claim, right? And that, I think, for me, Jafar, please share, but for me, I think that's very critical. I've shared with you, Jafar, other cases, yeah.
Okay, there's a question from Dr. Ramnan. I think we sort of covered it, but maybe you can clarify, Jafar. Can an insurer refuse coverage to a doctor? And has this happened before in Malaysia?
So, as an insurance company, the obligation is contractual. So, if it's contractual, they cannot refuse coverage. It's just that the doctors need to know what are they covered for. Most of the time, it is the doctors who do not understand what they are covered for and expecting something else than what they actually agreed. So this really brings me to the topic of doctors should pay attention to their coverage. They should really pay attention to what are they buying. Right? It's a contractual liability of the insurance company. They would not refuse the coverage that they have promised. Unlike a cooperative coverage that still can allow a cooperative to use discretion, but an insurance company owes a contractual liability. So the coverage that is promised, or it's in black and white, I don't see a reason why insurance company would refuse it. But doctors should pay attention to knowing what did they buy, what did they sign up for.
Yeah, I think we have all short time, but I think there's still some areas to discuss. And on this thing about buying insurance, I think we've mentioned it before, but I think Jeffai want to bring out about clinic indemnity versus,
yes, I must.
Yeah.
I know we are running out of time, but this is something which I really must insist. For all clinic owners, for the past 5 years, we have been, Dr. Shil have been promoting this knowledge very aggressively. Clinic owners, clinic is deemed to be a separate legal entity. A clinic should have an indemnity coverage by itself. Whether it's a sole proprietorship, partnership, or a Sidyan Bahad, it should. Especially if it's a sole proprietorship and if you have locums in the practice, definitely you must have a clinic indemnity. Yeah. Yes, and if it's possible, and I really recommend this, right? The doctors and the clinic should be insured, in my opinion, by the same insurance company to avoid any conflict when it comes to a claim. Because the plaintiff is going to name the clinic and the doctors. The doctors are shareholders of the clinic, right? And there could be conflict. So I really recommend that the clinic and the doctors are insured by the same insurance company.
Does the clinic indemnity cover locums?
Locums on their own. Anyway, locums are supposed to insure by law.
Okay. So hear that.
And please, this is something very, very important. Important to take note, right? All clinic owners ensure that the locums you hire have insurance. It's a must. Yeah. Because when they purchase when they renew their APC, the question would be asked whether if they are practicing locum, they need to have insurance. But some doctors at that point of time, they may not have foreseen that they may be working as a locum and they may not have bought insurance at that point of time. I'm not saying they would have done it willingly. They may not have seen that they would be doing locum and therefore they may not have bought insurance. But when they come to a clinic maybe a few months later, and if they do not have insurance coverage, then that's a liability. Yeah, it's not even legal for them. So they need to have their own insurance coverage. The clinic is not going to cover the locums.
So I think if you're government doctors, when they apply for APC, it's not automatic that they need to purchase indemnity, but except that if they are doing locums, but if they forget that they didn't initially, then they're later on doing locums, they have to actually purchase this on their own.
Yes.
There's a question, what is aggravated coverage? I'm not sure what the question is. Maybe Felix, you or
Felix.
Jafar.
Well, I mean, with respect to policy coverage, right? Then the answer would be is that you need to look at your policy that you buy, whether it covers you for aggravated damages, right?
Okay.
And aggravated damages, as both Jafar and I have shared, right? By far and large these days, it's being awarded by courts in Malaysia, right? Apart from general damages and special damages, the quantum varies, right? So, what is aggravated damages? If I understand the question, is that I will approach it this way: that the policy that you buy has to cover aggravated damages. And what I understand from Jafar is that Dr. Shield covers aggravated damages. You can share with us, Jafar, right?
Yeah.
And there are other policies that do not cover aggravated damages, right? And
I
aggravated
think it's
damages, sorry, sir,
yeah,
if they're
sorry,
not,
just to jump in. Yeah,
yeah,
they have
oh,
to
sorry.
just check with the insurance company whether they are. Yeah.
And if you're not covered for aggravated damages in the policy that you've taken, right, then what you need to remember, as we shared earlier, is that then you have to pay that yourself. Your insurer won't cover it. It's out of your own pocket, going back to your unlimited liability. And the highest so far is 1 million. So bear that in mind.
I think maybe they may also want to know what is aggravated damages. Felix, do you want to just give a very short?
Oh, I mean, you know,
Very short. Yeah.
I would like to share the exact principles of when a court should award aggravated damages. Unfortunately, it's a shifting position, right? So, given it's developing and shifting, right, I would say that you want to make sure, right, as doctors and consultants, when you buy your indemnity cover, that it covers you for aggravated damages. You just want to make sure that it covers you, and then you want to make sure, right, that the limit of coverage that you take, right, has to be sufficient. Because the maximum that has been awarded currently stands at about 1 million for aggravated damages. That's excluding general damages and special damages, right? And if you are orthopedic or ONG, right, another high risk practices, right? Like I said earlier, not telling you what cover to take, you got to think, right? But if you're high risk practice, 3 million ain't going to cover you in a claim. It ain't going to cover you. To be honest. Yeah. So don't forget about your personal liability, which is unlimited. And if you pass on, the liability on your estate. Yeah. And the runoff that Jafar has shared. Yeah.
Somebody wants to know what the defense fee of a solicitor is. What is a solicitor charge?
No, I mean, look, a defense fee is subject to the complexity of the claim, right? So it's hard to say. I can't tell you it's 5,000 ringgit, 10,000 ringgit, right? I can tell you this, for example, right? If you're looking at a full-blown trial in the High Court dealing with liability and damages, right? Liability and quantum, having experts on board, fighting the claim all the way in the High Court, and then going up to the Court of Appeal. If you go down or the other side goes down, like in Dr. Asila's case, Columbia Asia, I would say defense costs for the consultant, I would think that 300,000 ringgit is a no-brainer.
Okay.
I'm not saying that's, it could be cheaper, right? But I will give you, right, very extreme, the 300,000 ringgit is a no-brainer.
Okay. So, gentlemen, we have really overshot the time by 25 minutes, but it's quite late, and I think I want to thank you all for staying with us, both viewers as well as our panel. Just want to quickly mention there are previous talks, excellent talks by our eminent lawyers on aspects which cover things like documentation, informed comments, trends, medical report, and even if covered aggravated damages, what is non-delegable duty, etc. Actually, you just need to go to the web page. It's not just today's talk, but to learn more, if you want to know more about all these things, the previous talks also have covered a lot. So feel free to listen to them. And we hope that if we got questions, they can be answered by these excellent previous talk. They're all listed there. We've all our eminent lawyers have talked about aggravated damages, exemplary damages, and how they're defined. You just need to listen to all our previous talks. Okay. So I think the time has come to, I think what the doctors have been patiently waiting for is the CBD points. Please don't forget to subscribe to our channel for our upcoming talks. There'll be 2 more in December. Okay, 2 more talks in December from organized by Dr. Shield. So it'll be busy months in December. This is the link for you to get the attendance for tonight's talk, and it is dobbs.my/271124. And this is for the medical doctors, not the dental doctors. The link was already displayed earlier. So you can't click on this. So the QR code is there for you to scan with your normal QR code scanner. Mind you, this is not, I repeat, this is not the MMA app. This is your normal QR code scanner, so it will take you to the same link. And this link will take you to a online registration form. You just fill in your details, and we will upload the attendance tomorrow. Okay, this link will expire at midnight. Okay, after midnight tomorrow onwards, we'll still allow you to claim CBD points, but not by the attendance form, because it'd be very difficult to keep on uploading forms. But you just read the pinned comment in the video, and we'll tell you how to claim the points for watching the presentation and listening in. So I think if you have caught it late, you can still scan it later, and you have until midnight to submit your attendance. Okay, so I think I have to bid a thank you to your excellent discussion, gentlemen, and we will, see you. Thank you all for staying on until even the time is extended beyond the 9 p.m. Mark, and we'll see you again in the next one. So remember, there'll be 2 upcoming medical legal sessions in December, and they're very good topics as well. So stay tuned in our forums. We'll announce it and we'll email it out to all of you who are registered DOBBS members. Okay, so good night, Felix and Jafia. Thank you very much, and good night to everybody, and have a great weekend ahead. Yeah. All right.
Good night, and thank you.
Thank you. Thank you. Good night.
Thank you.